Ladies and gentlemen, good morning and happy Thursday. I hope everyone is doing well today. Y'all have been an extremely healthy jury thus far. We've been at this for several weeks, and as we were talking with Judge Smith before this trial started, we'd gone through a spate of trials that were fairly lengthy, where it seemed like jurors were just dropping like flies due to illness and whatnot. So y'all have been here every day paying attention, and that's the first thing that I want to relay to y'all is, on behalf of Brady Timms, our sincere thanks for that. Your lives do not get put on hold just because you are here serving your community in jury duty. Your work goes on, your family responsibilities go on. In effect, all this does is complicate those things. And yet you have been here every day, paying attention, giving us your time, essentially for free, although I know that the clerk's office has given you checks. And we greatly appreciate that. Abraham Lincoln said that there is no higher form of citizenry in this country than jury service. And we are very, very grateful for your time and your attention in this case. I'm holding in my hand right here my copy of the indictment issued against Brady Timms in this case. And what an indictment is a formalized allegation. It is not evidence. And the fact that Brady and Carrie Timms have been indicted for these offenses cannot be considered by you as evidence of anything in this case. Why is that? Well, it has a lot to do with the way an indictment comes about. It's a one-sided process. Folks are called in front of a grand jury and they give testimony, and a grand jury decides whether or not that testimony rises to the level of probable cause to issue an indictment. We don't get to participate in that process. Neither Ms. Bernard or I were even aware of when this case was going to be presented to a grand jury. Certainly our clients were not. We didn't have the right to ask any questions of anybody in the grand jury. I would posit to you that the first meaningful questions that were asked of many of the witnesses in this case came here in this courtroom when they were cross-examined. So that's why an indictment cannot be considered as evidence and is not evidence of anybody's guilt in this case. It simply forms the issue that you all have to decide. What we have for you to consider in this case today are counts 2, 3, and 4 of this indictment. I won't read all of the language, but what count 2 says is that Brady and or Carrie caused Jamison Timms, their child, cruel and excessive physical and mental pain by breaking his left 8th, 9th, and 10th ribs. And it says that they did that maliciously. Count 3 says the same thing, causing Jamison cruel and excessive pain by causing a compression fracture to his vertebral body T10. It says that was done maliciously. Count 4 says they caused Jamison cruel and excessive physical pain by causing facial injuries, plural, and a cut under his tongue. and it says that they did that maliciously. What you all have to determine in this case is this. Did the evidence and testimony that was provided on that witness stand prove beyond a reasonable doubt that they committed any of these offenses? That's the issue that you have to determine in this case. You're going to hear a lot about reasonable doubt this morning. When I first started law school at the University of Georgia, I was first or second week in school. I forget which class it was. I think it was criminal procedure. We were asked by our professor to write a paper on what we thought that meant. And being a naive first-year law student, many of us spent hours and hours and hours researching it and writing page after page after page of what we thought it meant, only to be extremely disappointed in the grades that we got and the note on the paper from the professor that said, a reasonable doubt is very simple. It's a doubt you can give a reason for. And that's it. The procedure in this case has been different. There have been witnesses called out of order, primarily because we were dealing almost exclusively with medical doctors. And both the state and the defense had to arrange testimony in this case based on their availability. We can't just call doctors and say you have to be here on such and such a day at 2 o'clock. Their schedules don't work that way. And what I want to stress upon you all is this. The burden of proof in this case rests solely with the state. We provided witnesses in this case to give opinions about issues that we thought were relevant. But we're not required to prove anything. Those folks right there, as they sit here, are innocent of these charges. And under the law, they remain innocent unless and until you folks say otherwise. They're not required to offer evidence. They didn't have to call one witness to testify in this case. They were perfectly entitled to sit there quietly, look at the state and say, put up your witnesses and we'll cross-examine them and let's see if you guys can prove it. So I want to stress that because I get a little bit leery sometimes in cases where we call quite a few witnesses. I don't want the jury to be under the impression that there's some kind of burden shifting that's happened here. I used to try cases in Bartow County with a lawyer when I was a lot younger, and in similar type cases, he would often tell the jury, the state's obligation in this case is to build a wall. And your job as a jury, if we put up evidence, is not to measure the walls and see whose wall is higher or wider or bigger. Your job as the jury is to examine the state's wall and see whether or not at the end of the day it is cracked or chipped or wobbly or not so sturdy. And each one of those cracks, each one of those chips, every little wobble is a doubt. And if the state cannot remove every single crack, every single chip, every area of unsteadiness in the wall, then they have not met their burden. The wall in this particular case, ladies and gentlemen, I would submit to you, is chock full of cracks. And my time today is relatively short, but I do want to spend a good deal of it discussing some areas where I think cracks have developed. During the relevant time period in this case, November 2021, January of 2022, how many times was this child taken to a medical expert to be looked at? Several. There were 0 missed appointments. In fact, extra appointments that were not regularly scheduled with the pediatrician were made, and the child attended those appointments. The child was taken to Erlanger Hospital to be reviewed by an entire team of medical experts. The mother was warned or told by her nurse friend, I think her name is Miss Wilson, you know, there's a possibility, given these markings that are on your child, they might make a CPS referral if you go up to Erlanger. Did that dissuade her and my client from taking this child to Erlanger? No. They literally took him up there, handed him to a team of physicians and said, check him out, poke him, draw his blood, run him through every machine you've got, figure out what's wrong with him. The child then was taken to CHOA in January. They knew full well what would happen at CHOA because they'd been through it at Erlanger. They knew the same process was going to happen. Did it dissuade them from taking this child down there? Absolutely not. Every time they voluntarily handed this child over and said, please look at him so we can figure out what's going on here. And ladies and gentlemen, I've been doing what I do for longer than I care to remember now. Those are not the actions of parents who are actively abusing their child. That doesn't happen. Usually it's right the opposite. Jameson was not being hidden. He was not skipping medical appointments. He wasn't rushed to the emergency room unconscious or with his eyes rolled back in his head or with a limb hanging down that he couldn't use. He was an overall well child. That's not what abusive parents do. It doesn't happen. That is a massive crack in the state's theory of this case. In January, Jameson is taken to CHOA. This is where things get interesting. Dr. Verena Brown testified in this case. She said she knew they were coming. She had talked to Dr. Garcia, talked about some images, some supposed bruises on this child. My quote from my notes was, I was there waiting on them to arrive. But if you want to analyze what happened next and put it in its proper perspective, in my opinion, ask yourself this question. Who's the first person from our community who arrived at that hospital? Detective Faulkner. That tells you everything you need to know about the objectivity of any medical examination of this child. When you are asked to go to a children's hospital and take your child there, and the police detective from your city beats you to the hospital, let me tell you something as a practicing attorney. That's only going to end one way. He's not driving down there in a taxpayer paid for vehicle for no reason. Criminal charges are coming. Based upon Dr. Brown's conversations with Dr. Garcia, whatever they were, whatever images she says she looked at, the decision, in my opinion, that this was an abused child had been made before they ever laid eyes on this kid. And they were going to search for something at CHOA until they found something to justify their premature rush to judgment in this case. On that note, since it seems to be that both the opinions of Dr. Brown and Dr. Messner, the world's greatest expert, who's the expert on everything known to man, who testified yesterday, those opinions were very, very much informed by findings and conversations with a Dr. Garcia at Erlanger. I think I was here for every day of this trial. Where was Dr. Garcia? Where were these images that these folks are up here referring to of these awful bruises on this child? The state of Georgia is a powerful entity, folks. All the resources they need. If they want to produce a witness, that witness gets on that stand. If they want to show you photographs, you see those photographs. Ask yourselves why you saw neither in this case. At CHOA, x-rays are taken. Healing tiny rib fractures are found on 8th, 9th, and 10th left posterior ribs. The question is, how did they get there? And when did they get there? I called as a witness in this case one of this country's most respected pediatric radiologists. She's literally one of the authors of the exam folks have to take to pass the boards to be deemed a specialist in that field. Her testimony was, based on her review, her blind review of the images and the records, that the rib fractures likely date to birth of this child and were most likely, in her opinion, caused by trauma during the birth process. She also testified that there was no compression fracture at T10. She would not have made that call. The testimony of Lisa Hutchison, ladies and gentlemen, I would submit to you, in and of itself, constitutes reasonable doubt to counts 2 and 3 of this indictment. She also testified that further imaging may have been helpful in this case, an MRI, a CT scan. If I recall correctly, Dr. Brown's testimony was, well, we just couldn't do that. It's a wiggly baby. Wouldn't have been good. Can't get good imaging that way. What did Dr. Hutchison say? It's no problem. Swaddle the baby when he's asleep, put him in there, it takes a few minutes. They just chose not to do it. Who is the expert who made these decisions about x-rays for the state? As I recall, her name was Dr. Dixon from CHOA. In fact, she's the chief witness in this case for the state. Everything kind of runs through her. Child abuse specialists are simply relaying what she says she sees in these x-rays. They're not radiologists. In fact, Dr. Brown admitted in her testimony in a conversation with our folks, she basically said x-rays aren't my thing. I leave that up to the radiologist. What do we know about Dr. Dixon's testimony in this trial? She came in here and lied to y'all. Flat out lied on that witness stand. She was being asked a line of questions. If you will recall, when she initially reviewed the x-rays, about T10, what did she say? It suggests a fracture. She comes into court, testimony's different. Oh, I'm sure. I'm sure. Well, it's not what you said back then. Well, I'm sure now. Well, who have you talked to between now and then? Have you talked to the state? Yeah, I talked to the state. Did you talk to Verena Brown? Yeah, I talked to her. What'd you talk about? Y'all remember what she said? Oh, it was a really limited conversation. The only thing we discussed is what we were going to wear for court. Is that it? That's it. Well, who's on the witness stand about 3 hours later? Dr. Verena Brown. Trying to get her to answer questions, which was difficult. Slipped in a question to her about that phone call. Did you talk to Dr. Dixon about this case? She said, yes. Really? What'd y'all talk about? Her images? Her findings? Now, it's not whether Dr. Dixon lied to y'all. The probative question is why did she lie to y'all? It's because they being the conglomerate at CHOA, I would respectfully submit to you, did not like the word suggestive in this case. They wanted it removed. Why? Because suggestive means uncertain. It means doubt. And that's why that conversation took place. And that's why she didn't want you to know that conversation took place. That conduct is disgraceful. It's beneath the dignity of this court. If she were my witness, her behind would have been back in that chair the same day, apologizing to each and every one of you. So I would submit to you, ladies and gentlemen, that the medical investigation in this case has a series of cracks, each and every one constituting a doubt. Jameson's health. I think the evidence in this case demonstrates that when this child was born, he was suffering from a constellation of issues. First and foremost, he was premature. His bones were not fully mineralized. Doctor who left his family vacation to come testify to y'all went through those images one by one. In his expert opinion, and he is perfectly entitled to examine x-rays and interpret them. I've got kids that play sports. They get hurt all the time. I have never encountered a situation where anybody other than an orthopedist examined their x-rays. That's not how it works. Orthopedists examine x-rays and interpret x-rays every day, contrary to what Ms. Fox would have you believe. In his opinion, he sees irrefutable evidence of metabolic bone disease, vitamin D deficiency. This child has a genetic variant at the site of the genome that produces what? Collagen. What is collagen? It's sort of the fiber that is the building block of our bones, of our blood vessels, of our ligaments, of our tendons, of our connective tissues. Nobody disputes that that variant is there. But it's a variant of unknown significance, which means we don't know how it impacts this child, and therefore we don't know how it impacts this case. As Dr. Krishnamurti testified, there are two things that are going to solve that equation: time and research. And that's it. I'll talk more about that variant here in a few moments. But those medical issues, ladies and gentlemen, present a whole nother series of cracks or doubts in this case. I want to talk to you for a minute about the credibility of the state's witnesses in this case. And I would say, from my perspective, if there's one pervasive theme that permeates their overall appearance in this court, it would be arrogance. They were arrogant, they were defiant, would not answer questions. One of them literally stood up and looked at Miss Bernard in an open courtroom and said, "I'm not answering your questions. I don't have to." The same one that looked at me and said, "Well, I'm the geneticist and you're not." The whole attitude, the whole vibe from most of their witnesses was, "Who are you to question us? How dare you?" Look what happened at CHOA with the defendants, Brady and Carrie Timms. They're conferred with by Dr. Brown, who says, "Well, these are the findings from the radiologists on the x-ray. We got to send some blood off to a lab." But that's going to take a couple of months before we know what the results are. Those vials hadn't even been labeled, much less put in the mail before what happened. These two are physically removed from that hospital. Look at how the family of these two was treated in this case. Trooper testified yesterday. He and his wife are stepping in trying to help Jameson. You would think that the state would be appreciative of that and treat them with courtesy and respect. Nope. Instead, he's harassed to the point of tears on that witness stand yesterday. Why? Why was he treated that way? A state trooper. He wouldn't kiss the ring, is why. He wouldn't bow down to these folks and say, yeah, we'll agree to just cut Jameson's family out of his life. And they tried everything within their power to have Jameson removed from his home. And it took the literal head of DFACS in this state stepping in to say, oh, no, that's not going to happen. You're not treating a state trooper that way. They put up a witness, Penny Miller, who outright said or implied heavily to y'all that those folks were assisting our clients in violating a court order. Some hanky-panky about visitation and where the child is. Trying to say that they didn't have appropriate provisions in the home for a baby, so I guess ergo the baby wasn't there. Nonsense. Abject nonsense. They even went so far as to try to convince Trooper vis-a-vis his testimony to change his testimony in juvenile court. Now imagine that. Imagine that. Cornering a state trooper in an anteroom and trying to convince him to say something bad about the grandmother of this child so that the case won't be transferred to Superior Court. That's the mindset that we're dealing with here. The overall attitude, credibility, conduct, and demeanor of the state's witnesses in this case, ladies and gentlemen, I would submit to you, presents another series of massive cracks and doubts in this case. There is no direct evidence in this case that Brady or Carrie Timms harmed a hair on this child's head. It just doesn't exist. The state is going to try to argue that the circumstances should lead you to believe that they did harm him. And that's what we call, ladies and gentlemen, circumstantial evidence. Here's kind of the way I always look at circumstantial evidence. If I step outside right now and it's raining and I see it raining and I get wet, that's direct evidence that it's raining. If I go to bed tonight and it's not raining, but I wake up in the morning and I look outside and the streets are wet and there's puddles in my yard, I can conclude that it rained. I didn't see it rain, I didn't get wet, but I can conclude based on those facts that it rained. Judge Smith is going to give you an instruction about circumstantial evidence. What she's going to tell you is that in order to convict these two based on circumstantial evidence, the facts have to be not only consistent with their theory of guilt, but they have to exclude every other reasonable hypothesis in this case. And if you can think of a reasonable theory or hypothesis in this case, then that mandates your verdict. It has to be not guilty. The defendants took this child to every required appointment, plus appointments that were made in addition to those appointments, to two of the largest children's hospitals in this area of the country, because they had concerns about his health. His health issues were related to a constellation of issues dealing with prematurity, bone mineralization, and a genetic variant. They were completely unaware of rib fractures because they didn't cause them. They happened during birth and trauma associated with compressive contractions at birth. They were completely unaware of a fracture at T10 because there was no fracture at T10. The child had a scratch on his face that developed impetigo. The child had a sore in his mouth that may or may not have been caused by inserting something into the child's mouth, but if the child has a connective tissue disorder, it could have been harmed without much force. That is not evidence that this child was abused or assaulted. Based upon the evidence that has been provided in this case, that is a perfectly reasonable hypothesis and explanation for what happened with this child. There may be others. I can promise you, all of you are smarter than me. If you come up with one, like I just did, know that it mandates your verdict in this case. And your verdict is not guilty. The final issue that I want to discuss with you, and it's the one in this case that I personally take the most umbrage with, and that is the issue of this genetic variant. This variant of unknown significance. Understand on that issue exactly what the state is asking each and every one of you to do in this case with that COL 1A2 variant in mind. They are knowingly and intentionally asking you to play a game of Russian roulette with the lives of two human beings. Their position throughout this case has been basically to just dismiss that. Well, probably won't happen. Not likely to be pathogenic. Well, how unlikely is unlikely? Oh, I'm not going to put a number on it. I have no idea. They don't know. And what if? I asked this question of 3 of the state's witnesses. None of them would answer it. They all wanted to change my hypothetical and pretend like I didn't ask the question. But I'm going to ask you all. What if a guilty verdict is returned in this case, and weeks from now, months from now, years from now, the research shows it's pathogenic. It certainly does cause connective tissue disorder. What are you going to say to them? What are they going to say to them? Nothing. Oops, our bad. That's not acceptable. This is a court of law. We don't treat citizens that way in this country. That is absolutely unacceptable. That in and of itself is reasonable doubt in this case. And based on that fact, this case should have never been prosecuted. Never been prosecuted. Ladies and gentlemen, I'm going to ask you in a moment to have the courage in this case to look at the government and say no. We're not playing this game with the lives of two human beings. I can't ask you for justice, ladies and gentlemen, in this case. Justice would be these folks getting 3 years back with their son. You can't do that. Justice would be compensating these folks and their family for the anguish that they've been put through for the past 3 years. You can't do that. What you can do, and what I respectfully request that you do, is look at these folks and say, no. You're not labeling them child abusers based on this evidence in our name. We're not doing that. Ladies and gentlemen, I greatly thank you for your time in this case, your attention. The evidence, in my opinion, clearly demonstrates that the state has not met its burden of proof. There is only one appropriate verdict in this case as to both defendants, and that is not guilty. Thank you.
Good morning, ladies and gentlemen. It's April 3rd. I spoke to many of you for the first time on March 3rd. And so I echo everything that Mr. Hood said about our extreme gratitude for everything that y'all have done for your jury service in this most important month of Carrie Tim's life. You really are the conscience of the community. You are doing your civic duty, your constitutional responsibility, and none of this could happen without you. In fact, it seems that no investigation at all would have ever happened without y'all sitting there and watching and looking at every single one of the witnesses that the state called as we tried to ask them the questions that frankly should have been asked 3 years ago before Jamison Timms was ever taken away from his parents, as happened on January 14th of 2022. I'll try not to plow too much of the ground that Mr. Hood so eloquently stated regarding the indictment and the burden of proof and the frankly massive failures of the state at every point to do their job and not bring charges like this against people without sufficient evidence. But we are where we are. And so I'll try to offer for you a timeline that matches up a little bit with what you heard first from the state in their opening about the life of Jamison Timms after he was born in October of 2021, to Carrie and Brady Timms, his loving parents who were so excited to have their first son and so concerned about the health issues that he was experiencing that they, as Mr. Hood said, brought him to those medical appointments, took those pictures, kept that binder of every time they visited a doctor and everything they learned and everything that they were trying to do to help their son. And when we think about what it means for why we're here and what happened, it does come down to that January 14th date, January 14th of 2022, when these folks with their family brought Jamison to a hospital that they trusted would act in the best interests of their son and help them figure out what was going on. And instead, they were subjected to the acts of, quite frankly, a conglomerate that ended up seizing him on a diagnosis of non-accidental injury, when those witnesses from that witness stand swore to you that no doctor had made such a diagnosis on January 14th, 2022. So let's talk a little bit about how we got there. First, it was Carrie and Brady noticing that there were some odd markings on Jamison. He was a premature baby. My client is a very physically tiny woman. It wasn't the easiest pregnancy, and Jamison was born premature. And any birth is a traumatic experience, bringing a new life into the world. You heard from the witnesses the forces that are exerted on the tiny body of that infant during the process are beyond what the strongest man in this courtroom could put on someone. And when that tiny little body doesn't necessarily have all of the collagen or all of the vitamin D or any of a number of other things, perhaps there's an effect from an anti-nausea medicine or a blood pressure medication. These things affect serotonin levels, and we learned that serotonin levels affect the collagen development and structure of the bones. There are any number of reasons why there might be enough of a tiny weakness in the premature body of Jamison Timms that you get those tiny, subtle rib fractures as he's being born, as his mother is bringing him into the world. So when those markings appeared, you heard from family friends of Carrie and Brady Timms, people who are themselves mandated reporters, people who are putting their own professional licenses and credibility on the line to come here before you and speak on behalf of Carrie and Brady. They told you what happened. Carrie immediately called her nurse friend and FaceTimed her to show her what was going on. And that friend, she didn't say, oh, well, not a big deal. You're just an anxious first-time mom. She said, honestly, that does remind me of vitamin D deficiency. At the worst case, it could potentially be leukemia. You need to take him in to be seen. And so that's what they did. They took him into Erlanger to be seen. And ask yourself the same question that Mr. Hood referenced. Why you didn't hear from Dr. Carla Garcia, the pediatrician specializing in child abuse, who saw Jameson up at Erlanger in November of 2021 and who talked to Dr. Brown and who, let's be honest, probably talked to Dr. Messner too, since his memory got so weak when it came time to remember who you had talked to about Jameson's case. I submit to you that if there were any suggestion that those were actually bruises inflicted by Carrie or Brady Timms, that you would have seen pictures of them, you would have heard from the doctors, you would have heard from medical professionals who could tell you about that. Instead, you heard from medical professionals found by Carrie and Brady Timms, like Dr. La Posada, someone with a resume as long as my arm from some of the most prestigious institutions in the world, who told you certainly that this was a connective tissue issue. It wasn't what was flowing through Jameson's veins. There was a structural integrity issue with his blood vessels. And he could tell that because of the way that the markings appeared and disappeared, the way that they followed lines on the body, the way that they in no way resembled bruises inflicted on a child. Dr. La Posada came before you and put his credibility on the line to offer that opinion. The state couldn't even be bothered to make a record of those photographs for the doctors or the investigator or for you. But somehow that evidence was still strong enough in January 2022 for Dr. Verena Brown and Dr. Stephen Messner to refer to it repeatedly in their notes as though it were evidence that these people had done something wrong. And so I think they lied to you, ladies and gentlemen. I think we are in a situation where a baby was taken away and nobody wants to take responsibility for it. Everyone who came before you on that witness stand wanted to blame somebody else for that decision. I submit to you that if Jameson was actually the victim of child abuse, that if the state were actually representing the interests of Jameson Timms as they came to you and told you they were doing almost a month ago, then they would have had at least one witness who would have taken responsibility for that decision to remove Jameson from his parents. Because let's be clear, 3 years later, sitting in this nice, comfortable courtroom, it's sometimes a little hard to grasp just the gravity of what happened, of young parents bringing their child to the hospital, hoping to find out what's going on, and ending up leaving escorted by a security guard while their baby is kept from them. This is like a civil death penalty. To take away a 3-month-old child, a child who is still being fed and cared for by his parents, an infant who cannot do anything on his own, to take him away from his parents, that's the kind of thing you really need to be sure about before you do. And frankly, I have some concerns with the whole idea of a medical diagnosis of abuse anyway. That seems like the sort of thing that you would want to gather information from other sources about before drawing a conclusion. But that's not what happened here. As you heard, the first person from Gordon County to make it down to CHOA on January 14th was Detective Faulkner, the investigator who, by his own admission, did not investigate the case. He simply took the word of Dr. Brown. But what was the word of Dr. Brown, ladies and gentlemen? We heard from her on 2 separate days of testimony. Her head did seem to be a little bit clearer the second day, but I do worry if maybe the way that she was, well, maybe just having a bad day that Wednesday that she testified, Maybe she was having another bad day, the day that she saw Jamison Timms and drew the conclusion about non-accidental injury. After talking to Carla Garcia, numerous social workers, numerous DFACS liaisons, again, none of whom were brought before you. The names that came up, Heather Gates, Rachel Johnston, Anna Ray, the doctor who admitted Jamison Timms to the hospital on January 13th, Dr. Xenia Fleming. None of these people brought before you. None of the nurses brought before you. None of them whatsoever. And ladies and gentlemen, I submit to you that the reason for that is that the state is trying to conceal that Jamison Timms was a clinically well baby. Every time he was brought in to a medical practitioner, even when he was brought in on January 12th to Dr. Sarah Harbin Pickett, who I know it was several weeks ago, but you'll remember her demeanor on the stand. It was not one of, hey, this was my concern, I had to call it in. She was nervous and anxious and defensive. And that's because I think she was having a lot more contact with the other doctors who made these decisions in January than any of them wanted to be honest about. The state is trying to rely on a photograph that Dr. Harbin Pickett took on January 12th for evidence of a mouth injury to Jamison, where she was poking at his mouth with a stick, where her clinic had been suctioning mucus from his mouth. So after Jamison had been handled by them is when that photograph was taken. But of course, we don't have a photograph from when Dr. Verena Brown examined him on January 14th. We have a photograph of his face that she took. We have a photograph of the bruise on his back that was caused by CHOA when they x-rayed him that morning. But we don't have a photograph of this alleged frenulum injury that forms the core of the state's case that this baby was being assaulted and mistreated. And I submit to you that it's because the medical notes were correct. The medical notes from CHOA were correct on January 13th when they said frenulum appears intact at this time. That's why you didn't hear from any of the nurses that were handling Jamison. That's why you didn't see a picture from Dr. Verena Brown, because it didn't fit with their idea that Jamison was suffering from, what was it Penny Miller said? Horrible injuries. Because that's how this case ended up where it is, ladies and gentlemen. No, I don't think that the people who came before you on the stand get up in the morning and think, oh, how can I take somebody's baby away wrongfully? No, nobody's doing that. At least I certainly hope not. But what they are doing is relying on information from other people that is not actually reliable. And so the whole core of this case comes from the notes that Verena Brown made in January of 2022, where she tried to make it sound like Jamison was something other than the clinically well baby she acknowledged on the stand under cross-examination. They tried to make it look like he had a constellation of injuries so that anybody, the DFACS employees, the investigators, the judges, anybody else who was involved in the case would look at that report and think, oh my goodness, fractured ribs, a torn frenulum? This poor baby has clearly been horribly, horribly abused. That was the conclusion that they drew. And that's why it's so good that y'all are here to do the investigation that was not done by law enforcement or DFACS or even the medical professionals who were responsible. And honestly, the experts, we had a lot of medical testimony. Thank you all so much for hanging in there for it, because it does get a bit long at times. But I think everybody here understands that a family's entire life is at stake. And when those are the stakes, yeah, we're going to go through every single word in that medical report. We're going to go through every single factor that could have influenced these decisions and these findings. So what we had from CHOA is a series of medical professionals agreeing with their coworkers. That's what they did. And they acknowledged that. There was some attempt to, provide this idea that they were somehow objective. Oh, look, we saved a baby on Christmas Eve from being taken away from his family because a doctor was about to take him away from his family on Christmas Eve. But when I asked Dr. Messner on cross-examination if he could think of a single example where there had been a finding of non-accidental injury by a colleague that he had then disagreed with, there wasn't a single one. It's because they've boxed themselves in. What are they going to do? Say, we were wrong? We shouldn't have taken your baby away? I guess the past 3 years were all for nothing? No, they can't do that. And I think we know why. We heard it when we asked them about the medical attestation form. The doctors, were concerned about their own legal liability. Suddenly, they became really worried about whether or not they had all of the records and documents. I submit to you the time for that concern would have been when you were making the diagnosis of Jamison Timms, not just when you were talking to the lawyers in your department. That memo, that change in protocol from DFACS that came down in February of 2025, that didn't happen for no reason. That happened because this isn't the only family in this situation. It happened because of Jake's meeting with DFACS. If that's how they treat a sworn officer of the law, imagine how they're acting towards Carrie and Brady Timms. At various points throughout this month, I will admit I have found myself getting a bit frustrated with some of the witnesses. Sometimes even to the point of being a little bit upset myself with the way that they have conducted themselves. It's not the way that I would expect fair-minded, honest people seeking to present the truth would act. But then I realized that was actually a gift. It was a gift to all of us in the courtroom, and particularly to y'all, because if this is how they act in court, in front of a judge, to officers of the court and to y'all, imagine how they were acting behind closed doors to Carrie and Brady Timms. People that they had complete control over. People whose baby they had complete control over. And it's not a pretty picture. It's not a picture of people acting in the best interest of Jamison Timms. It's the interest of people trying to protect a decision that was made and push it all the way through. I asked y'all during jury selection if you'd ever had occasion to be around government employees who'd gotten it wrong in a situation. And that's what we're dealing with here, ladies and gentlemen. Government employees and government adjacent employees who got something wrong back in January 2022 and are trying desperately to protect themselves and cover themselves rather than honestly seek the truth. So their witnesses are people agreeing with their coworkers. Our witnesses, who again, we did not have to put up a single witness, but what could Carrie and Brady Timms have been doing for the past 3 years other than investigating and trying to figure out what's going on with their son? And in the course of that, they connected with internationally recognized experts in their fields of genetics and orthopedic surgery and pediatric radiology and metabolic bone disease and connective tissue disorders and bleeding disorders. These are all people, again, putting their professional credibility on the line to make a record of their statements. And they've definitely don't have any interest in protecting child abusers or making excuses for child abusers. These people were contributing their time largely pro bono because they reviewed the facts, they reviewed the medical records, and it was clear to them that this was not a case of child abuse. So when you compare the evidence that was brought forward, don't fall into the trap of comparing the walls. But honestly, the wall that Dr. Hutchison and Dr. Pauls and Dr. Krishnamurti and Dr. La Posada have built is a strong one. Because it's not like anyone is trying to find some reason that Jameson broke every bone in his body. This isn't a situation where he had horrible injuries. This is a situation where he had a little something wrong with his connective tissue, a little something wrong that you find on call 1A1 and 1A2 and SP7, something that's just a little bit off, made his bones a little bit weaker, made him a little bit more subject to having those birth-related fractures that even Dr. Messner on the stand acknowledged. Yes, we have to do these surveys because sometimes the fractures are too subtle for us to see. And so that's why you can look at these yourself. These will all go back with you in evidence. All of these x-rays from every time that Jameson was seen. And you might find yourself in the same position as Investigator Faulkner of not even being able to identify the x-ray that actually shows this purported injury because it is so minor. And the timeline that Dr. Messner offered of the healing fractures, it didn't even make sense. It doesn't make sense on a medical level. It doesn't make sense on a factual level. You heard from the people in Jameson Timms and Brady Timms and Carrie Timms' life about what was going on. They were regularly seeing family and friends. They were going to the home of family and friends. They had family and friends coming to their home. They're taking Jameson out to other places. They're doing as much normal stuff as you can do while you're still kind of in the middle of the COVID times, November 2021 to January 2022. There was no possible time that Jameson could have been subjected to some horrible injury, experiencing tremendous excessive pain, and then not seeing a medical professional, but yet when he's got a scratch on his face, they bring him right in. It doesn't make sense. The people who got up on this stand and put their own credibility on the line for Carrie and Brady Timms wouldn't have done that if they thought there was a chance that these people had caused those injuries to the baby. They aren't people who are looking to make excuses. They aren't people who are looking to people who are looking to make excuses or tolerate excuses from anyone. They're people who are honestly seeking the truth. And Carrie, well, it's been a hard 3 years. You saw the disrespect to which witnesses for the defense were subjected by the state, not using their medical titles, referring to the foundations they started because of their international work in metabolic bone disease as a hobby, referring to, well, don't you want to get a real radiologist to listen? Again, imagine if that's how they're treating a doctor on the stand, how they're treating these people behind closed doors. And yet through it all, they continued to do everything right. They continued to comply with the court orders. They continued to show up. They continued to do what they were supposed to do to try desperately to reunite their family. So, again, we have to come down to who's responsible here. Who is responsible for what happened to Jameson Timms? And I submit to you that if these people were guilty, you would already know. And the state would have called all of those people. They would have had at least one person to say, yep, I saved Jameson from that unsafe environment. I stand by my decision. But they didn't. No Lori Stanfield. They did call April Hunt, remember? She was the one who actually visited Jameson's home with Carrie and Brady there, right after this allegation was made on January 12th. She saw their home. She saw them feed their child. They undressed Jameson to show his physical condition. And you heard her on the stand say, yes, I was surprised when I heard these medical findings from O.C.G.A. She was surprised because she, like Dr. Brown, like Dr. Messner, she saw a clinically well baby. Dr. Krishnamurti saw a clinically well baby. In her practice, she's seen abuse. She's a mandated reporter. But she, having actually treated Jameson Timms and interacted with the family, she is confident that there is no abuse going on, that there is only a family trying to find answers. But unfortunately, they haven't been able to rely on the justice system to help them get those answers, because that timeline of the January visit to O.C.G.A. and then the March 14th issuance of warrants on very, very serious felony charges, there was no investigation that took place in there. They did have the genetic variants, right? And that's genetic variants. You know, you heard the state repeatedly say it's a genetic variable. No, it's not a variable. It's a variant. It has been tested multiple times, and Jameson has a genetic variant that is carried through his paternal line on the collagen-producing gene. He's got one for SP7 and one for COL1A2. That information was available to the state when they lied in their warrant and said all theories of OI have been excluded. And that's what I think you're probably going to hear from the state. You know, we will not have the opportunity to come back and speak to you. The state does get the last word. I warned you in jury selection. They get to sit closer and they get the last word. But we know what they're going to say. They're going to say Jameson had no further breaks once he was out of the custody of his parents. But remember, the state repeatedly was angry that Jameson was having so much contact with his parents, allowed by the court, even after these allegations were made. That was why they dishonestly tried to remove him from the home of, because they believed that there were unsupervised visits and too much contact with his mother, Carrie Timms. So when you go back into that jury room, think about that warrant from March 14th, 2022. Then it took them, the state, 2 years to indict the case. 2 years of Carrie and Brady continuing to do everything right. You know those state's witnesses would have loved to have some violation they could have cited. Something where somebody did something in violation of a court order. They would have loved that. They put their energy into trying to find that, and they couldn't. These people have done everything right for the 2 years leading up to the indictment and now the 1 year leading up to trial. So Carrie is living the truth of her love for her son every day. For those on the jury who are people who have had the experience of being parents, might have had the experience of having a moment where you can't see your child when you expect to. Maybe it's a crowd, maybe they're playing, and they just get out of sight for maybe a second. And that feeling of horror and the pit of your stomach dropping, where is my child? That's the feeling they've almost had to have for 3 years. And they are so incredibly fortunate to have the support of a loving family. Again, not a family that's going to make any excuses, a family that's going to investigate things for themselves, hold people accountable, and show up to support what is right. You've seen them show up every single day of this past month. That wouldn't be happening for child abusers. It would never be happening for child abusers. The state's theory simply doesn't make sense. It doesn't make sense why multiple mandated reporters would vouch for these people. It doesn't make sense that Jamison was allegedly diagnosed with non-accidental injury on January 18th of 2022, 4 days after he was taken from his parents. You heard the DFAC's testimony saying, we rely on the experts. But do they? Did they actually talk to any of the doctors? Did they ask the questions? Did they ask to see the scans? Did they ask questions like, if this was an inflicted injury, why were there no other signs of abuse? No blood in the eyes, no blood in the brain, no soft tissue damage, no bruising? Because frankly, it is up to y'all to judge the credibility of each and every witness, whether they're an expert or not. But I personally have a very hard time believing Dr. Messner when he says that it is possible to squeeze a child so hard that you fracture his ribs while causing no bruising, soft tissue damage, or internal damage to the organs whatsoever. You'd see things like elevated lipase levels. And we don't have time to get into every single one of the dishonest things that Dr. Brown said, but when we went through the entire CHOA medical record with her and all the places where there were abnormal readings that she had put in her report as normal, and then when we asked her about it, oh, it doesn't matter anyway. It doesn't matter anyway. How many times did we hear that? If it didn't matter, you could have been honest about it in your report, and then maybe we could have believed you that it didn't matter. But as it stands, I don't think you can. The ribs would have been displaced if this was inflicted trauma. There would have been evidence of soft tissue damage. There would have been evidence of bruising. None of that was there. What makes sense is what Dr. Hutchison told you, what Dr. Hutchison explained, that these cannot be excluded as birth-related injuries, and what Dr. told you about the bubbly appearance of the healing callus not being normal, not having enough mineralization from the premature body to be able to heal completely normally. So, that DFACS form, that DFACS policy that we now have to allow parents to get a second medical opinion, it's precisely because of the way DFACS was treating people like Carrie and Brady Timms, who just wanted to figure out what was going on with their baby, and who were accused of being underhanded and non-transparent from the same people who put in the medical record no pre-notification of the parents and then took the child away. Those people are accusing our clients of being underhanded and non-transparent. What a joke. The fact that this medical attestation form, this most basic thing that any doctor should be comfortable saying, yes, I reviewed this child's record. Yes, I am making a diagnosis of non-accidental injury basically a civil death penalty for the family because a diagnosis of non-accidental injury is going to get the kid taken away, but you're worried about your own legal liability. Well, I submit that maybe they should be. Maybe they should be worried about making sure that they have all of the facts and that they are getting everything right before they make a determination like that so irreversibly changes the trajectory of a family's life. They should have to get that right. I just keep thinking, we so want to be able to talk to you again after the state does, because that's kind of been their game from the beginning, is hiding the ball. We didn't hear what their actual theory was of what was done to Jamison until this trial, until they were actually asking people on the stand. And those people were saying, well, maybe it could have been bending or squeezing or grabbing or any of these things. We didn't get to hear about that until this trial. And so you will hear from them, oh, he didn't have any additional fractures. Well, you heard from Dr. and other doctors that environments change over time, medication exposure during pregnancy changes over time, deficiencies change over time. Things can get cleared up, and thankfully that is what appears to have happened with Jamison, that these were early in life issues that hopefully will not continue to be serious issues for him. But I guarantee you that if those genetic tests had come back without a genetic variant, the state would have been all over that as evidence that there is no possible genetic cause for this. So I'm with Mr. Hood. If you had nothing else before you other than the genetic irregularities in collagen production, that would be enough for reasonable doubt in this case. But when you combine that with the open dishonesty and concealment of evidence, the failure to photograph, the failure to record and maintain records of the accusations being made, and then lying to us on the stand about the conversations you had, what were they trying to hide? I think it was that they made the decision to take Jamison away before Jamison even got to the hospital, really. The skeletal survey was a formality. They were looking for something. And I don't know why they would want to do that. But they did. That's what happened. And so all that's left at this point is for you, the ladies and gentlemen of the jury, to make the right call here. And I think everything Mr. Hood said about reasonable doubt is absolutely correct. There's no way that the state has built a wall free of cracks here. They have not in any remote way excluded all reasonable theories of innocence. They have disrespected, dismissed, and marginalized all reasonable theories of innocence. They have done that directly to the Tims. They have done that to the Tims family members. They have done that to the Tims counsel right here in the courtroom. That is how they have treated reasonable theories of innocence. But that is why we have you, ladies and gentlemen. The judge will tell you in the charge that you will evaluate credibility and bias towards a party. And I would argue that every single one of the state's witness was biased against Carrie and Brady Tims from the moment they talked to Dr. Carla Garcia, who was not brought before you, or the moment they talked to Dr. Verena Brown. People who wanted to come before you as child abuse pediatricians. Not pediatricians, not people who are concerned about the best interest of children, but people who have spent their entire careers in this closed environment of child abuse, of 100% child abuse cases. Because when you have a hammer, everything looks like a nail. But this wasn't just one of thousands of cases. Like with Dr. Messner, how, we had to keep bringing him back to, we actually want to know about Jameson's case. What did you do in Jameson's case? He wants to, he's very good, looks at the jury. He and Dr. Brown, they spend a lot of time talking to prosecutors. They speak to prosecutors' conferences. They help prosecutors prosecute. They spend their time learning how to talk to the jury, how to make things sound good. Our witnesses were more nervous and concerned and not as practiced in telling those stories to juries. But the truth, I think, shone through. And so I think not just the state hasn't proved their case against Brady and Carrie Timms, because they haven't, but I think the state's actions have proved a case against DFACS and against CHOA and against Dr. Brown and Dr. Messner and every single other person who had their name associated with this travesty of justice. They will never get the past 3 years back with their child. But what they can do is move forward with cleared names and a readiness to focus on their family and their son. And you can do that. You notice how everybody stands up when y'all enter or leave the courtroom. And we've got a big jury box, and so we all try to make sure we stay standing until everybody, including on the end, gets a chance to sit down. That's because y'all are the most important people in this courthouse. You are definitely more important than the lawyers, even more important than the judge. Because people who deal with these cases all the time, it's easy to say, well, sure, this report sure makes it sound like he's got horrible injuries. Why would I need to check into that? I'll just trust what these other people said. But that's the telephone game that brought us here, and that's what y'all have the chance to put a stop to. And so that is what I am asking you to do. I am asking you to listen to what the state says and see if they even have remotely a reason for not bringing Dr. Carla Garcia, Dr. Xenia Fleming, Heather Gates, Anna Ray, Rachel Johnston, Lori Stanfield, Dylan Scher, any of the nurses or other medical professionals who interacted with Jameson directly. I don't think they're going to have one. Ask them, think about if they have a reason for why their witnesses lied to you about who they talked to, what they talked about, whether they could remember it. Ask them why they are willing to call the work of an internationally respected geneticist who maintains the database of genetic variants, why they are willing to call his testimony a nothing burger. The man is recovering from a stroke and still made time to come before you and put his professional reputation on the line. I don't think they're going to have any answers. And so here is what my ask is to you on behalf of my client, Carrie Timms. Please listen to the state, go back to the jury, listen to the charge of the judge, go back to the jury room, elect your foreperson, talk about the case, and return your verdict of not guilty as quickly as possible, because that will be the message that you send that it's not okay to lie and intimidate and torment a family just because you're trying to cover up for a doctor's bad decision. That's not okay. And then, once this is all over, we can explore what we learned about Dr. Brown and Dr. Messner, because you have to be a board-certified licensed physician in the state of Georgia to make any diagnosis. So who made that diagnosis on January 14th if it wasn't Dr. Brown and it wasn't Dr. Messner? Who made that diagnosis that stole those people's baby away? The state's not going to have an answer for you, and so that is our humble request with immense gratitude for everything that y'all have been through and everything that you have brought to this process. Thank you, and we humbly request a verdict of not guilty for both Carrie Timms and Brady Timms. Thank you.
Court, Mr. Hood, Ms. Bernard, and ladies and gentlemen of the jury. Between November the 21st of 2021 and January the 3rd of 2022, Jamison Timms suffered while he was in the home of his parents. He had 3 of his ribs broken. That is not minor. It's not trivial. It's not insignificant. He had 3 broken ribs. Between November the 18th of 2021 and December the 30th of 2021, Jamison Timms suffered while he was in the care of his parents. He had a compression fracture on T10 of his spine. That is not insignificant. That is not trivial. And between January the 10th of 2022 and January the 13th of 2022, Jamison Timms suffered while in the care of his parents. He received a facial injury and a cut under his tongue. The injuries were painful. All the injuries would have been obvious to the caregiver. The mouth injury would have bled a lot, and the mark on his face was noticeable. The defense is not required to put up any evidence at all. But when the defense puts up evidence, the state has an opportunity in this particular case to examine it. The defense put up several theories. If every defense that was suggested is true, Jamison Timms would have been the most unluckiest baby that's ever been born on the face of this earth, because he would have vitamin D deficiency, birth-related injuries, temporary brittle bone disease, osteogenesis imperfecta, possible Ehlers-Danlos syndrome, metabolic bone disease, genetic issues, Cole-Carpenter syndrome, craniosynostosis, collagen issues, and a mineral issue regarding the mom's prescription drug use during pregnancy, all at the same time. The state would submit that fortunately for Jamison, none of that is true. Quite frankly, when we were sitting there, expert after expert, many of their experts shot down the other experts' theories. But I want to take a minute to address each one because I want to remove the doubt that might have been suggested when they mentioned each one. I want to start with vitamin D. Carrie Timms was pregnant during the summer here in Georgia. Her friend, Kelly Adams, said they spent a lot of time outside together. She was soaking up that beautiful sunshine, getting plenty of vitamin D. We also live here in Georgia. The weather in the fall is the best it's going to be because you got the beautiful springtime temperatures and no pollen. And Jamison's vitamin D was normal. It was tested at CHOA, and it came in at 32.9. Low as anything under 20. Jamison Timms did not have a vitamin D deficiency. Dr. Krishnamurthy, his geneticist, confirmed that he did not have a vitamin D deficiency. Dr. Brown confirmed he did not have a vitamin D deficiency. Dr. Messner confirmed he did not have a vitamin D deficiency. Dr. Dixon confirmed that there's no indication of any rickets or other bone abnormalities that are associated with vitamin D deficiencies. Vitamin D deficiency is not a defense in this case. Temporary brittle bone was suggested. Well, you just break a little bit and then you're going to be better and never break again. That is a theory that has been completely debunked by the medical community. Their own expert, Lisa Hutchinson, told you that the Society of Pediatric Radiology has confirmed that that is not a thing. It has been debunked. She also told you that the Society of European Pediatric Radiology has also found that temporary brittle bone does not exist. It is not a defense in this case. It is not a doubt. I want to spend a few minutes on the birth-related theory, because the theory, if taken as true, would be that when Jamison was born, he broke his ribs when he was being born. And that's why they're on the x-ray on January the 14th of 2022 when he's at CHOA. The state had a number of radiologists testify, and each radiologist to a person said that after a break, the calluses will start to form after 7 to 10 days. 7 to 10 days, 7 to 10 days, 7 to 10 days, 7 to 10 days. Jamison was born on October the 8th of 2021. He was in Erlanger Hospital having his first skeletal survey on November the 18th of 2021. 5.5 weeks later, there are no broken ribs on that scan. It has been reviewed by Dr. Appleton, who testified here. It was reviewed on a reread by Texas Children's Hospital. There were no broken ribs. It was a normal exam, a normal radiograph. And in this particular situation, we are fortunate because when you have a break, it is the standard practice of all the hospitals to turn around and have another exam 2 weeks later. They do that because you could have some very minor fractures that are not visible on that first scan. And when he went back in on December the 8th of 2021, he again has normal exam, no broken ribs. Why is that important? Because when Dr. Hutchinson testified, she's the only one who did not say 7 to 10 days. In fact, she said it could be up to 6 weeks before it would appear on an x-ray. Well, we were 5.5 weeks in November, but guess how many weeks old he is on December the 8th? Exactly 2 months old, minimum of 8 weeks old, and there are no fractures on the scan from December. He did not have birth-related fractures on his ribs. His ribs were broken by the time he gets to CHOA in January, but they are not broken on the December 8th scan. And you will have those scans out there with you. And I pulled some of them because I think it's so important. For a matter of perspective, 6GG is the scan from CHOA that shows the 3 broken ribs. And you had multiple times to see large on the screen, the bulbous at the end, that is where the body was putting callus around that fracture. You will also have back in the jury room with you 5B. 5B is the chest x-ray from Erlanger that was taken in November that shows his beautiful little ribs that have not been broken. You will have back in the jury room with you 5AA, which would be, again, the chest x-ray that he had taken in Erlanger that was read by Dr. J. Coleman that shows his beautiful little ribs, and none of them are broken. But as I indicated, you will also have with you 6GG, which will be the January scan from CHOA that shows the 8th, 9th, and 10th rib with the callusing around the bone. You will also have back with you 6GGG, which is going to be the February scan, which shows that, unlike what Dr. said, that it's not healing normally, that's why it's so bulbous. By the time we get there on February, for the February exam, his little ribs are beautiful again. And that is going to be on 6GGG. And you'll have an opportunity to pull that out of the evidence, examine it yourself, and see that this child's ribs healed beautifully. I want to point out also, in connection with the hypothesis that it was a birth-related injury, that you can't have a compression fracture in birth, because compression fractures occur with the squunching. And with the birth, if anything, there's pulling to get that baby out. In this particular situation, the state would submit it is scientifically impossible for this particular baby to have broken his ribs in childbirth, because they are not on the November scan, and more importantly, they are not on the December scan, some 2 months later. So even by her own testimony, and she's the only one who doesn't say 7 to 10 days, she said it would have showed up at 6 weeks. It is not on the scan that was taken when he was 2 months old. These are not birth-related rib fractures. The state submits that that defense does not hold water. As to the metabolic bone disease, you did hear from Dr. is an orthopedic surgeon who explained to you that after his retirement, he took an interest in going to underdeveloped countries and to learn what he could about the situations that people there that aren't getting fed properly and things like that, and how it affects the bones. And after his travels, he came back and studied all that he could. That was essentially what he told you. He is not a radiologist. He did not go to radiology school for the 5 years that Dr. Lisa Hutchinson did from the defense. He is not a pediatric radiologist. That is, he did not have the additional 1-year training that Dr. Coleman and Dr. Dixon and Dr. Lisa Hutchinson had. He's never sat for boards for radiology to get certified. But he comes in here to court and tells you that he and only he can see metabolic bone disease on the scans that were read by Erlanger Hospital, Children's Healthcare of Atlanta, and the rereads that were done at Texas Children's Hospital, and quite frankly, Lisa Hutchinson. He said this metabolic bone disease is so obvious that a medical student should have been able to see it, that it just jumps right out at you. And I specifically asked Lisa Hutchinson, did you see any metabolic bone disease? And she said, no, I wasn't looking for it, but no. What about flared ribs? She said, well, I wouldn't have used an x-ray to see flared ribs anyways. I would have done a different type of exam if I was looking for flared ribs. Dr. Nicholas Appleton, who read the original scans at Erlanger, was specifically asked, did you see any evidence of metabolic bone disease? And he said, no. And I went down the list. Flared ribs? No. Cortical tunneling? No. Was his sutures closing too soon? No. His scans were reread by Texas Children's Hospital. They agreed with Dr. Appleton. Then you heard from Dr. J. Coleman. He was my radiologist that's actually a pediatric radiologist that had to testify via Zoom. Normal exam. Specifically asked, did you see any evidence of metabolic bone disease? No. Flared ribs? No. Cortical tunneling? No. All of the different terminology that Dr. eventually used. No, no, no. Normal exam. Dr. Paula Dixon did the first read at CHOA. Did you see any evidence of metabolic bone disease? No. Did you look for flared ribs? There are no flared ribs. Did you see any evidence of cortical tunneling? No, there is not. Did you see any femur bones hidden in bones? No. Did you look specifically at this one section? Yes. Did you see it there? No. Went through the exact report. No, 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 no. Her scans were reread by Texas Children's Hospital. No mention of metabolic bone disease. Agreed with her analysis. There's another set of scans that were done by Dr. Dixon from February. Again, any metabolic bone disease, any wormy in bones, anything at all. No, no, no. Jameson was back at CHOA in June. It was read by a different one that was tendered through Dr. Krishnamurthy. Was there any evidence? No. Their own Lisa Hutchinson did not see evidence of metabolic bone disease. She said, I didn't know anything at all about the case. I'm sitting down blind looking to see what I could find. She did not find metabolic bone disease. There are 7 radiologists against Dr. and the radiologists do not see metabolic bone disease in this case. The state would submit they have not proved metabolic bone disease. In addition, when Dr. Krishnamurthy arranged for his bone density scans, they are normal. Ehlers-Danlos syndrome was hypothesized, I think, in an opening as a potential defense. First of all, Carrie Timms does not have EDS. She was examined by Dr. Kathy Stevens. She was given the Beighton scale. She could only score a 2, and that was for her elbows. She could not score on any of the other factors that they test. A 2 is not high enough for a diagnosis of EDS. She also did not have doughy skin. She did not have unusual scarring. There really was no point in testing further. She does not have EDS. Dr. Kathy Stevens physically examined Jameson. Number of things in play. Number 1, he did not have doughy skin at 8 months old. She also said that babies and children cannot be diagnosed with EDS. They can't be diagnosed because they're already bendy. If you ever changed a child's diaper or hold them and they flip on back, babies can bend in all sorts of shapes and sizes. Doesn't mean they have EDS. They're just very bendy. I would also submit that even if, say the state's wrong, and eventually he grows up to be diagnosed with EDS, broken bones is not one of the criteria for an EDS diagnosis, particularly for hypermobile EDS. It's not a factor, non-factor. It's not what it causes. It might cause your joints to be loose, but it doesn't break your bones. The state would submit the floated theory of Ehlers-Danlos syndrome was not at issue in this case, and the state has rebutted that. I want to spend probably, like the other attorneys, more of my time on genetics. There are 2 main genetic sites that account for most OI, or osteogenesis imperfecta, cases in the United States and the world. One is QAL1A1. His is normal. All the experts agree that's a non-issue in this case. You probably heard more than you wanted to about QAL1A2. We spent a lot of time with the different experts talking about that particular abnormality in Jameson's genetic code. Because on intron 9, at the end, he has an interchange between a T and a C. And when I was cross-examining Dr. Pauls, and there are many of you, there is one of me, and I'm taking notes the best I can, but I specifically asked him about that particular receptor site because he had testified previously on direct that it was a non-factor because the site was not likely to alter mRNA splicing. So I asked him point blank, are you saying that we're basically wasting our time talking about this? This is not the cause of his OI. And the state would submit, he said, yes, this is not the cause of his OI. Now, he went on to hypothesize that there are many, many, many other kinds of genes that were never even tested that could cause OI, but this one did not. We had wasted our time talking about this intron because it would not affect splicing. And if it doesn't affect splicing, it doesn't change the clinical things that could be caused when you have something a little off in one of your genes. His skeletal bone surveys do not show any evidence of osteogenesis imperfecta. He doesn't have curved bones. He doesn't have wormian bones. That was confirmed by Dr. Appleton, Dr. Coleman, Dr. Dixon. Dr. Kathy Stevens specifically said, I am not diagnosing him with OI. He doesn't have it. Dr. Krishnamurthy, after all of these years and all of these tests, is still saying, I would call myself neutral. I cannot say this is child abuse, but I also cannot diagnose him with anything genetically. We just have to wait. I am neutral. That's what she told you. She has not diagnosed him with not one genetic thing, period. When it comes to Dr. Krishnamurthy, you also have to look at where is she getting her information. Aside from the tests that she's running, which are solid, a test is a test. What it says is what it says. She's getting information and feedback from the family. Well, somebody's had hearing loss. Well, did they tell you they live near a racetrack? Well, no. Wouldn't that be an environmental reason for having some hearing loss? If you only get pieces of information, regardless of what doctor it is, it's harder to make a good diagnosis. Dr. Pauls said, well, your testing in America is insufficient, but he was only given the 3-panel test. Did you know we did a 24-panel? No. Dr. Stevens ordered it. We had the results. Did you know we did a 67-panel? No. Dr. Krishnamurthy ordered it. We have the results. If you only give people just little pieces, it's harder to give the best interpretation of what all those pieces mean. As to SP7, Dr. Krishnamurthy, Dr. Stevens both said this is not the cause of the medical issues in this case. And quite frankly, when it comes to Dr. Stevens, the state called her as a witness, but she was found by the defense. She received a referral from Dr. O.C.G.A. Dr. O.C.G.A. is the pediatrician that replaced Dr. Harbin Pickett. And Dr. O.C.G.A. referred the child to the geneticist in Chattanooga. The geneticist in Chattanooga who says, this is a healthy baby boy, period. Nothing wrong with him. You also heard that he has a microdeletion on the long arm of chromosome 15 at 15q11.2. Experts for both sides agree that this is not connected to the broken bones issue in this case, period. I told you that Dr. Paul said, well, it could be something else that hasn't yet been tested for or found. But I would submit that Dr. Pauls is also biased. There's been a lot of comments made about the state witnesses. Dr. Pauls clearly doesn't like child abuse prosecutions. He even said there's no such thing as shaken baby, even though we all know there are many national cases where the...
If she's trying to get into some sort of evidence that she didn't bring out at trial about shaken baby syndrome, that's entirely inappropriate.
Your Honor, I have allowed both defense attorneys to make their closings without objection where they were saying what they thought, what they knew, and what other experiences they've had personally and professionally. I'm allowed to say what the national news says in my closing.
I mean, I think if she wants to talk about a news story, that's one thing. If she wants to offer her opinion on another kind of syndrome and prosecutions of other families in that situation, I don't think that's appropriate, Your Honor.
I would sustain the objection as to the point Ms. Bernard is making, but you can certainly discuss a national news story.
Thank you, Your Honor.
We have all seen the national news stories where the nanny cams in the home caught the babysitter or the significant other or someone connected to the baby shaking it. There has been one in nearly every state. It happens. It's physically possible to happen. And those families have to live with the devastation of what happened to their baby, and it was caught on film. The state would submit that Dr. Pauls is biased. He is biased against child abuse prosecution. Dr. Paul's opinion at this point is just a guess. just like it was a guess that Jameson would eventually have craniosynostosis, where his skull would fuse together too soon. That did not happen. That has not happened. He has a normal head by everyone who's examined him since. It was also an incorrect guess that Jameson would have Cole-Carpenter syndrome. He does not have Cole-Carpenter syndrome. Again, it was a guess that was wrong. The two geneticists who actually examined Jameson have not diagnosed Jameson with osteogenesis imperfecta. The state would submit that the purported theory that because he has an anomaly in his gene, as so many of us do according to the geneticists, it's not unusual to have an anomaly. But in this particular case, his anomaly did not cause the issues that you're sitting here and need to decide. The state would also suggest that the medications purportedly taken during pregnancy also did not have an effect on Jameson. You heard yesterday that anti-nausea medicine could have effects, but it's not on the bones or collagen. You heard iron pills could have an effect, but it's not on bones and collagen. You heard yesterday that the heart type medications could have an effect, but not on bones and collagen. The state would submit there's been no evidence put before you that would suggest that anything that Ms. Timms took during her pregnancy led to a situation where it's caused Jameson's broken bones in this case. Lastly, I want to talk just a minute about the collagen before I go into what facts have you heard that support a conviction in this case. First of all, your collagen is your body makeup. It is what it is, and it doesn't change. He never broke again with anyone else. He never had significant bruising again with anyone else. It is not something you outgrow. It is not something he had an issue with when he had his vaccines, when the veins are actually punctured and weakened, they close properly. When he had his blood drawn and the vein is actually punctured and weakened, it closed properly. There is nothing in the medical evidence that you heard that would support that he has a collagen issue in this particular situation. I would also ask you to look at where the bones are fractured. He has a fracture at T10. It's in the vertebrae of his spine. It's not the long bones. It's not the bones that he would be able to move and other people would generally come into contact with. It's literally in his spine. The same with the broken ribs. Collagen's throughout your whole body. He's not bumping up against the walls and people and breaking the long bones and the things that people are in contact with. These are very specific injuries, and they're specific for abuse. I do have the burden of proof in this case. The state has to prove this case not beyond a shadow of a doubt. That is not the standard. That's a phrase that people have used, but that is not the standard that we're held to. The state doesn't have to prove this case beyond all doubt. That is not the standard. In fact, the judge will specifically tell you, I do not have to prove this case beyond all doubt. It's not to a mathematical certainty. That is not the standard that I'm held to. The standard that the state is held to is a standard called beyond a reasonable doubt. A reasonable doubt is a doubt of a fair-minded, impartial juror that is honestly seeking the truth. The truth is borne out by the evidence. And what is the evidence in this case? Mr. Hood pretty much laid out what evidence is. It's direct or it's circumstantial. Direct evidence is eyewitness testimony. That is, I saw something happen. Like little in the back seat saying, I'm sitting in the back seat and I see Brady reach behind and do an aggressive act against Jameson, and he watched it happen and he feels bad about what he saw And it's affected him 3 years later when he's sitting on the stand talking about what he saw his dad and the demeanor he had when he's talking about playing ball and doing all those fun things, and the demeanor he had when he started describing what he saw his daddy do to his little brother and how his little brother had just been crying. He was just crying. He's a baby. And what he saw his daddy do? That is direct evidence. Is the state saying that that's the act that broke the ribs and that's the act that caused the compression injury? No, we're not. What he describes as being, I think, from his viewpoint, it looked like he jerked him by the thumb and flung him to the front seat. And he was upset because the baby was crying. And we already heard from multiple experts that the ribs broke from squeezing and a slamming for the compression injury. But it's direct evidence of how Brady Timms acted around Jamison Timms when he was upset about Jamison's crying and Carrie's not around. Direct evidence is also the x-rays. I told you you could pick up the x-rays in this particular case because they're going back with you. 6GG, you can see the 3 broken ribs. You can see the calluses around them and the little bulbs at the end of it. That is direct evidence that on this day, this child has healing broken ribs. The state would also submit that 5AA, that December picture that's so important, is direct evidence that on that day, there are no broken ribs. The state would also submit that 5B, that November skeletal survey, is direct evidence that on that day, there are no broken ribs. Direct evidence. Circumstantial evidence is very much what Mr. Hood says. I can go out in the rain and get all wet. That's direct evidence. I watched it hit me. But it's also going to bed at night and waking up in the morning and seeing the puddles all over and saying, it's rained. Circumstantial evidence is just as good as direct evidence because all of our murders are circumstantial evidence. Our victims can't talk. All of our cruelty cases on our infants and toddlers are circumstantial evidence because they can't talk. But the evidence itself is just as good and just as strong as direct evidence. I want to go over a timeline with you because I think in this particular case, the timeline gives you a really good picture of what was going on in the home and the circumstances that led up to Jamison being abused in that home. Jamison was born on October the 8th of 2021. When he was born, multiple experts have testified it was uncomplicated, normal vaginal delivery. And he was 37 weeks when he was born, which means you are a little premature. 38 weeks, one of the doctors said would have been normal. I think some people go up to 39 weeks would be normal. 36, earlier than 36 would be a preemie. But he was healthy. He was seen at 5 pounds, 15 ounces then, but then he got to go to Dr. Pickett on October the 18th of 2021 to set up for her to be his pediatrician. And when we got there, she gave him an exam and said he's a normal little baby. His head's normal. All his bodily functions are normal. All his the things that she tests for, the heart, ears, nose, throat, all the different things she did, normal. They wanted him circumcised. She asked some special questions. Have you had a family history of bleeding? No. Why is that important? Well, because if he had a family history of bleeding, I don't want to do that in my office. I could still do it, but we'd need to do that in the hospital. And she did the circumcision, and it went just fine. Just minimal bleeding. He didn't bleed out all over the place. His little veins didn't collapse. He had exactly what she expected would happen with the circumcision. The only difference is he actually healed quicker. On October the 28th of 2021, they were back at Dr. Pickett's office, and on that date, their concerns were some feeding problems, that he was a fussy infant, that he had a little bit of gas. They'd changed him from breastfeeding to formula. She noted that his circumcision was well healed and that he had a normal exam. On November the 18th of 2021, he's back at Dr. Pickett's office. Dr. Pickett said, well, I wasn't the one that examined him that day, but I know he was there, and I did go in and look at him. There was a claim that the bruises had come up overnight. or the night before rather, and that they were actually darker the night before. She called them a pattern bruise. When they were in her office, she thought there seemed to be some pattern to it. But she was concerned. There was no bleeding disorders in the family, but she was concerned that there might be an underlying medical cause for the problems in this case, and asked that they go to Erlanger Hospital, which they did. When they got to Erlanger Hospital, there were no broken ribs. The 10T was measured at 8 millimeters high. As I indicated, no metabolic bone disease, and they did a workup on him, and eventually he was discharged from the hospital in November, which is why that November date's so important. They were given some specific instructions, but they didn't follow them. They're mad at Erlanger because he lost some blood, and they were asked to go to Rome and get some blood so they could finish all the testing. We know that they didn't do that because when they went to Dr. Pickett on December the 9th, they hadn't done it, and she reprinted the request to go over there and get the blood done. The perception and the image the defense wants you to have is that this is a family that is concerned about their child, and they're doing everything that they're told because they want answers. But when it comes to the November incident, they never got the blood work done that they needed to finish the answers for the November incident. They didn't do it when Erlanger asked them to. They didn't do it when Dr. Pickett.
Wait.
She has gone well beyond any evidence that they have had ample opportunity to introduce during the course of this trial, which they have not introduced any of these witnesses from Erlanger who they say are going to testify to what she is mentioning in her closing arguments.
Your Honor, I'm commenting on facts already in. This is the second time they've been interjected, and I didn't like everything she said, but I wasn't objecting what she said. We're allowed to comment on the facts and evidence, and that's a fact Dr. Pickett testified to, which is why she reprinted the order to go do it again.
Let me see you at the bench, both of you. Mr. Hood.
Dr. Pickett testified that she had to reprint the request for Floyd Hospital's blood work, and that when she followed up on it, the Tims had not taken the baby to have that blood work done. The state would submit that they did not try to do everything they could to get answers for the baby's situation. And my question is, if that is your argument now, why not? In addition to appearing there in December, there were some other things going on in the home at that time. Number one, all the witnesses have testified that Jameson was a colicky baby. A colicky baby cries a lot. When people are pregnant and they're expecting their baby, you have a vision of what you think life's going to be like with your new baby. Most people don't envision the baby crying a lot and not being able to make that baby stop crying because they're colicky. In this situation, she was able to spend the first 8 weeks on maternity leave with her baby and went back to work at the beginning of December and was fortunate enough to work from home. When they went in December the 8th to Erlanger, as I already indicated, which is our next big date, there were no broken ribs, no metabolic bone disease, nothing wrong with the baby. On December the 9th, the very next day, both Brady Tims and Carrie Tims took the baby to Dr. Sarah Pickett's office. They had concerns for colic and were getting vaccines. The baby is still crying all this time out that they are going to their pediatrician and saying, basically, we have concerns. This baby is crying and crying. It was at that point, as I mentioned, that an order was printed for them to continue to do the hematology workup. And the next time Dr. Pickett sees Jameson is going to be on January 12th. The state wants to go back and address again in this time frame. Because what we have is a baby that cries. He cries a lot. People handle crying babies differently. Some people, like who testified, she said, crying babies don't bother me. Some people it does. What described is a very aggressive act by a grown man on a little baby that had to have occurred while Jameson was under 3 months old. Because after Jameson's 3 months old, Brady Timms is not alone with Jameson Timms. And what he sees happen and what he told y'all was that Daddy's in the front seat, and that he's in the back seat, and Carrie's not in the vehicle, and that the baby was crying. Well, apparently nothing new because the baby cries a lot. And that his daddy reached back to the back seat and grabbed that baby from his little 6-year-old perspective by the thumb and fling that child to the front seat. And he was upset for the child. He said it made him sad because Jameson was just a baby and he was just crying. That's what's going on in the home. There's an additional statement you heard, and it was from Carrie Timms to Dr. Pickett. It was stated on January the 12th of 2022 when they were at the doctor's office. Carrie Timms, quote, mother stated that father is sometimes easily frustrated with the infant, and that the infant doesn't want to take the bottle from him. From now on, she's going to be the person that gives Jameson his bottle. What injury was he there at the doctor's office for? It wasn't the cut under his tongue. The injury that he was there to see Dr. Harbin Pickett for is State's Exhibit, looks like number 9. This is the mark on his face. The mark has been described different ways by different people. Some people have called it a scratch. Some have called it an abrasion. Dr. Pickett said it had like a skin, like you would skin your knee. But in addition, you heard yesterday that it had an appearance of bruising underneath. You have the exhibit. Take it back and examine it. This is a little baby. Dr. Pickett said this is concerning for abuse because of its location. It's on the fleshy part of the cheek, and there's just one. It's not something the child would have done to himself. When it happened rolling over, it's not consistent with happening on a soft bedding or a mitten. That's why he was taken to the doctor's office. While at the doctor's office, the tear under the tongue was discovered. State's Exhibit number 1. It is a classic feeding child abuse injury. Someone did something to Jameson by shoving something in a protected area of his mouth. Your lips protect that part. Your teeth and gum area protects that part. Your tongue goes over that part. Something has been crammed under the child's tongue to cause this tear. It is not a torn frenulum. We never said it was a torn frenulum. We said it is a cut under the tongue. The cut nicks up next to the frenulum, and you can clearly see it in the picture for yourself. The fact that Chilla later says the frenulum intact, I disagree with that. It is intact. The cut is next to it, and you can see it in State's Exhibit number 1, and you'll have that picture back to look at yourself. Dr. Brown said when he's in the hospital the next day, now this picture is taken on January the 12th. She sees him on January 14th for the first time, and she says by that time it's already healing. It doesn't look like States 1 when she testified from the stand. That's much more defined, clear, precise. When I see it, it's already healing because that part of your mouth heals very quickly. And you know that, ladies and gentlemen in the jury, from your own experience of having bitten your tongue or bitten your cheek. It heals quick. In this situation, the state would submit that there was a crying baby, that he didn't take his bottle well. The state would submit that his little face was grabbed and something was shoved in his mouth under his tongue to cause that cut. And it has nothing to do with quel 1A2. It has nothing to do with the collagen. It has nothing to do with his genetics. It has nothing to do with his hereditary. It has something to do with his caretaker. And the people responsible didn't care enough about him to not cram something under his tongue when he's crying. That's child abuse. And I'm not going to stand here and apologize for prosecuting child abuse. While I was there in Dr. Pickett's office, Carrie Timms is tearful and anxious. Dr. Pickett moves an appointment up that was for her so that her associate can directly talk to Carrie Timms and deal with Ms. Timms. Sarah Harbin Pickett had to report this as abuse. She didn't have a choice. That's what being a mandatory reporter is. You heard from mandatory reporters from both sides. Mandatory is exactly what it says. When you suspect abuse, it must be reported. It is out of your hands. It's a crime. If you don't, you must report. Sarah Harbin Pickett reported suspected abuse. The other thing in connection with Sarah Harbin Pickett, she never got to see Jameson ever again. She was no longer the pediatrician. We know that because when they were at CHOA, Carrie Timms told Dr. Brown, Dr. Pickett's not going to be our doctor anymore. And we know that because Dr. O.C.G.A, pediatrician, referred Jameson to Dr. Stevens. If you really believe that your child has a medical issue that's been discovered, even as a result of child abuse report, wouldn't you be thankful? Wouldn't you say, wow, now I'm going to get my child the help it needs, we're not going to have problems? She wasn't thankful. She's angry, and you're not going to be the doctor anymore. On January the 13th and 14th of 2022, Jameson was at CHOA. He was admitted as a patient. His T10 was all the way down to 6 millimeters. 8 millimeters at Erlanger, 6 millimeters at CHOA. It's been compressed. There was a reference in opening statement that his heartbeat only went up after his mom left because he was missing his mom, and that was his way of saying it. The evidence was that on January 13th, while his mom was still there, his heartbeat was off the chart. It's off the chart because he cries. He's crying a lot. On January the 14th of 2022, he was seen by Dr. Brown. She confirmed that they did not have a history of osteogenesis in the family. She confirmed that no one in the family had frequent fractures. Carrie told her that she was struggling with postpartum depression. That's a real thing. It's not something to be overlooked. And I'm glad that many of her friends and family who testified said they didn't really know. But you have a new baby, he's colicky, you're dealing with your own problems, and you've gone back to work. It's tough. They said they didn't really leave the house much. They'd stay mostly at home. Dr. Brown said when that cut under the tongue happened, it would have bled a lot. And you know from your own personal experience, when you have any injury around the head, it's going to bleed a lot more than seems like the rest of your body does. She said it was less than 72 hours old, and that it would heal quickly. Ms. testified that she had Jameson in her home for about a week, and that he was a fussy baby and he cried a lot. But he had no new breaks in her home. He had no new bruising in her home. There was a juvenile court hearing on January the 21st, I guess to follow up on the court order where the judge had signed to take Jameson. And at that time, Jameson went home. He was still colicky. But no new breaks in the home, no new bruising in their home. And on February the 3rd, he was brought to Dr. Messner. At that time, his ribs had healed. And the report from Dr. Dixon on February 3rd, the follow-up, compression, fracture, no suggestion. It's a suggestion in January, but it is confirmed in February, and that's the facts. On February the 6th of 2022, Elizabeth Bono from the Department of Family and Children's Services actually had an opportunity to observe the family with Jameson. Her testimony is that the mother was very bonded to Jameson. But after 2.5 hours, when the father finally got the baby from the mother, he turned and immediately placed him in a bouncer. No cuddling, no nurturing, no snuggles. He put the baby down. On February 15th of 2022, he went to his first visit with Dr. Krishnamurthy. She again confirmed it was a normal vaginal birth. He was 37 weeks old, but he'd been making all his normal milestones. It's important because if he had some of these other issues, he wouldn't be doing that. On June the 16th of 2022, his compression fracture had healed, and it now measured, T10 measured at 9 millimeters. On June the 21st of 2022, Dr. Kathy Stevens saw him for the first time. As I indicated, he was referred by Dr. O.C.G.A. She confirmed that Carrie Timms does not have EDS, that Jameson is a healthy baby boy, the genetic tests are a non-issue, they were not likely to alter splicing, that he did not have osteogenesis imperfecta, that he did not have EDS, his skin is not even doughy, and that there's no correlation between broken bones and EDS. On July 28th of 2022, you heard that the custody went to his grandparents, and on August 4th of 2022, they officially have the child. There's no new breaks, no new bruising, and Defects closes their case the very same month. Jameson had a bone density test done in July of 2024 that is normal, and in August of 2024, when Dr. Krishnamurthy follows up with him, he's still meeting all his normal milestones, and she orders the 67 gene panel test in September of 2024. Still no diagnosis from Dr. Krishnamurthy. As we sit here today, now knowing all the actual facts, I would say that law enforcement failed Jameson Timms. They didn't fail him because of what happened in January. They failed him because of what happened in November. In November, you know that a detective was also at the hospital, Annette Brennup. And you know that Jody Faulkner tried to talk to her about it now when he has this case. She didn't want to talk about it. She was retiring. There was no investigation. Nobody looked into it. The state would submit that defects.
I would object to this. Again, they're trying to go into evidence that they had the opportunity to bring before the jury regarding the November incident. They had the opportunity to call in or anybody else that they wanted to. But for them to be offering argument regarding evidence of the investigation in November when they did not bring it before the jury through any witnesses or competent evidence is entirely inappropriate, and I would object.
Your Honor, Detective Jody Faulkner said he looked for the report, couldn't find it, found Annette Brennup, and she didn't want to talk about it. That's the facts.
And I did not object to her saying just those words, but as she continues to go into her opinion on what was or was not done during the law enforcement investigation in November, that's what is entirely inappropriate, Your Honor.
Okay, well, I would say this. I mean, again, the ladies and gentlemen of the jury have heard testimony from many, many witnesses in this case, and it's up to them to determine the credibility of the witnesses. Let's just stick our closing arguments to the testimony of the witnesses that testified, and let's move on.
The state would also submit that defects failed Jameson. We know that April Hunt was involved in November, and we know there was no case. The state would submit that if services had been offered in November, that if anything had been done to go into the home and investigate further to see that Carrie was dealing with postpartum problems, that the baby was colicky, that possibly what happened in December and January could have been prevented. But no services were offered. Nothing was done. They failed Jameson. The defendants were the only caretakers of Jameson Timms. We know that he was a crybaby. He had colic. He can't help it. He's a baby. We know that on at least one occasion, Tilton saw his dad acting aggressively towards Jamison. When you put that with the statement of Miss Timms, that Mr. Timms gets frustrated easily with a baby, that he didn't like taking the bottle from him, the state would submit Jamison's ribs did not break themselves. Jamison's T10 was not compressed by itself. It takes a lot of pressure to break ribs. They're anchored by the spine in someone's back. It takes a significant amount of force to cause a compression issue, to cause that spine to actually, on that vertebrae, squunch. The skimp mark was not caused by rolling over. The cut under the tongue didn't spontaneously happen by itself. Dr. said that when you have trauma, that is the kind of trauma we were talking about, when you break someone's ribs and cause a compression fracture, the lipase could be elevated for up to 2 weeks. The state would submit that the reason why his lipase levels are noted normal in January is because those injuries are older than 2 weeks, that they occurred closer to that December timeframe when they're going to Dr. Pickett and asking for help with their colicky baby, when we know that he had a normal skeletal survey from Erlinger on Dr. J. Coleman's follow-up. And I would again submit that that fits the facts in this case, because on January 14th, the ribs fractures are visible. But in February, they're back to beautiful looking little baby ribs. You would never know that he was fractured in this case. Their own expert explained that there wouldn't be any treatment for rib fractures that are that old, and that in this particular situation that he wouldn't think you'd do treatment for a compression of only 2 millimeters, that you would only start treatment when it was compressed more than 2 millimeters for sure. I think he threw out the number 5, but I don't remember that. You'll have to rely on your own memory on that. The state would submit that based on even that expert's assessment of the injuries, they're not minor, they're still injuries. But in this particular situation, they didn't need any medical intervention. He was given essentially baby aspirin, Tylenol, ibuprofen at the hospital, but they didn't have to set, there was no reason to set ribs or put them in a body cast. He was clinically well, but he was still abused. As I indicated before, the state would submit that the defense witnesses in most respects canceled each other out. The opinions like Dr. Krishnamurthy are really only as good as the information you're given. If you're not given all of the facts, it's really hard to come in here and give all of the information that she would potentially have the expertise to give. And where she says she falls is neutral. I can't diagnose him with anything genetically, and I can't say it's not child abuse. I just have to wait and wait and wait and see if there's more tests done on the road. As far as the friends and family who came in and testified, the state would expect people's friends and family to come in and support them when they're accused of a crime. It's not something unusual, particularly in any case I've ever tried. But they weren't there 24/7. None of them certainly saw what saw. And if they did see what saw, would they have testified differently? The reality is Jamison never broke again. He never bruised again, and you don't need to leave your common sense at the door. You'll have a copy of the indictment out with you. And there's a couple principles in play when you're looking to see whether or not the state of Georgia has met their burden of proof. The defense says, well, they didn't call every possible witness you possibly could in this entire case. You can tell from the buggies that are being pushed in and out, the volumes of medical records and people that have handled that. We've already been here a month. The state brought you everything that we believe you need to see that we have proven our case beyond a reasonable doubt. The state would also submit, although they are not required to put up any evidence at all, if they had something in those volumes of evidence that I've already given them, that they thought helped them, they'd have called them just like they called the other witnesses. Not required to.
I would object, that's improper burden shifting. We are in fact commenting on the state's failure to call witnesses for its case in chief. It is entirely improper for them to suggest that we should have called the state's
I'm
witnesses.
going to sustain that objection.
There's case law that supports what I've just done. If they say I didn't do it, the state's allowed to say they could have.
I'm going to sustain that objection.
Thank you.
For purposes of closing argument, I'm sustaining that objection.
In this particular case, they are charged as parties to the crime. Parties to the crime can be proved by many different ways, and you can be a party by participating in many different ways. You can be party if you directly committed the crime. You can be party if you intentionally helped someone commit a crime. But you can also be a party if you advised, encouraged, hired, counseled, or procured another one to commit the crime. What is the intent needed in this particular crime? The intent in this crime is malice. Malice can also be proved in more than one way. And the definition that the state wants to focus on is the very last definition, because the state would submit that fits this case to a T. Malice also means willfully doing an act while aware of a strong likelihood that the actual thing could be the result. So what you're basically looking at is, in this particular situation, we all know you would never do this to a baby. We all know you would never do this to a baby because they could get hurt. There's a likelihood that they could get hurt if you do that to a baby. We would never do this to the baby or shove something in there because you know there's a likelihood that they could be hurt. That is the intent of malice that the state submits, that the person that hurt this little baby did when they did these acts. And there's only two people caring for this child. In count 2, they're accused of cruelty to children between November the 21st of 2021 and January the 3rd of 2022. The important language is maliciously causing Jamison Timms, a child under the age of 18 years, cruel and excessive physical pain by breaking the said Jamison Timms' 8th, 9th, and 10th left ribs. That's what I had to prove. The state would submit that we've done that by showing they are the only caretakers, that there is not another explanation for these broken ribs, that it occurred in that time frame because we can prove that because he did not have broken ribs on the prior scans, and that it took a significant amount of force to break the ribs, and the testimony was whoever broke them knew it. You would know when you did it that you have hurt that baby. On count 3, they're accused in a similar time frame of maliciously causing Jamison Timms, a child under the age of 18 years, cruel and excessive physical pain by causing a compression fracture to the vertebral body of T10. The state would submit that the force necessary of slamming that baby down, whether it's slamming it into a chair or a car seat or anything that would have caused it to compress, when you do that with a baby, you know you could hurt the baby. It doesn't matter you didn't know that an x-ray is going to show it or not. You knew you could have hurt the baby if you do that to the baby. Count 4, quite frankly, the state would submit we have the most evidence on. We have the evidence that Carrie says, from now on, I'm feeding the baby. We have the evidence from Carrie that he doesn't take the bottle well from Dad, and that Dad's easily frustrated. We know that it happened within 72 hours of presenting at the Dr. Brown on the 14th, based on her assessment of how quickly it had healed. We know that it is fresh appearing to Dr. Pickett, but it did not bleed in her office. So it's happened before and it's not bleeding. And that it would have bled a lot when it happened. The state would submit in this particular case that that child's face was squished and something was shoved in his mouth, under his tongue, in that nice little protected area, and it caused the tear that is visible in the photo that you'll have out there in State's Exhibit number 1. And for doing that to a little baby, they need to be deserved to be held accountable for that. And we're going to ask for a verdict of guilty as to each and every count in this particular case. The state would also thank you for your service in this case. It is not easy to set aside your lives and to sit through a month's worth of testimony, and a lot of it tedious. Genetic testimony is not an easy concept for a non-doctor, and y'all listened carefully and took lots of notes, and we appreciate the time and your attention, because quite frankly, the state would submit Jamison deserved someone taking the time and attention to look into the situation, to examine the evidence on both sides, to see what factors are in play. What happened to him mattered. His was broken. It's painful to be broken. The state would submit, when you look at all of the evidence, including the statements by Ms. Timms and the statement of Timms, that at the end of this case, you will find that Jamison Timms was abused. Now, quite frankly, on behalf of the state, we don't like everything that we heard that defects, people who worked for them or were hired out by them did. I've adopted a child through defects. It's no fun being under the microscope, but we would expect anyone who stepped up to take care of a baby to be treated with respect. But it doesn't change the fact that Jamison Timms was an abused baby. And as the state, we have a responsibility to protect that baby until he can be put into a place where he's safe. And apparently he's safe now, living with the grandparents. Mom and dad see him apparently. A lot of people testified they're still around him. But he deserved a chance to get out of infancy and to be safe. In conclusion, in this case, we would ask that you find the defendants guilty. They are the caretakers, and he was hurt in their care. And you've already heard the mechanisms that it took to cause those severe injuries and how he would have suffered. And for that, the state would ask you to hold them accountable. And I want to again thank you for your time and your attention in the case.
Thank you, Ms. Fox. If you'll turn the lights up, please. That would conclude the closing arguments.